afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Brian Hogan presenting for us. If you are unfamiliar with the format of this event, first, Brian is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Brian will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Brian to get us started.
Thank you, Marissa. So as she mentioned, I'm Brian Hogan. I'm a supervising attorney in the Greensboro office of Legal Aid of North Carolina. And I'm here today to talk to you about Social Security disability law. More specifically, though, today we're going to talk about the medical standard for disability and Social Security disability insurance and supplemental security income cases. So just for some background, though, before we get directly into the topic, the Social Security Administration administers two disability benefits programs for disabled individuals. The first one, as I mentioned, is Social Security Disability Insurance. The acronym or abbreviation is SSDI. And the other disability program administered by Social Security is the Supplemental Security Income Program, or SSI. These programs have different non-medical eligibility criteria. Social Security Disability Insurance is an insurance program, and when you're working and paying your taxes into the Social Security system, you're doing so so you can become insured for benefits if you retire or become disabled. And so to meet the non-medical eligibility criteria for SSDI, it's going to be based on essentially your work history. And it's more complicated than that, but for the purposes of today's presentation, that's where we're going to leave that. For the SSI program, that is a means-tested program. So what that means is that the non-medical eligibility criteria are going to be based on income and resources. And your income and resources have to be below certain thresholds in order to be non-medically eligible for those programs. Now, what's similar between both programs, though, is the underlying definition of disability, which is what you'll have to prove when you apply and go through the appeals process that you meet if you're applying for disability benefits. And that definition of disability is here in front of you. The SSA regulations define disability as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. Now, there's a lot going on in that definition, and we're going to try to unpack that in the next few minutes here for this presentation. But if you apply, you're going to hear that that's what the definition of disability is. So let's talk about what it looks like in actual practice, though. So when you apply for benefits at your local Social Security office or for SSDI, you can apply online. You're going to be asked a series of questions to determine your non-medical eligibility, but Social Security is also going to ask you about your medical treatment history and about where you get medical treatment from, because after they take your initial application, assuming that you meet the non-medical eligibility criteria, they're going to send your case to a place in Raleigh, North Carolina called Disability Determination Services, or DDS. And at DDS, your case is going to get assigned to an analyst who's going to collect those medical records, review them, and have one of Social Security's internal medical consultants offer an opinion on them. And their opinion is really, really important for certain steps in this 5-step sequential evaluation analysis that you see on your screen. So again, that definition of disability that we noted before in the prior slide is pretty complex, but here's what it means in practice. Social Security, when they're analyzing your records and in your work history, is going to ask a series of 5 questions in a sequential fashion. The first question is going to be, are you engaging in substantial gainful activity currently? If you are engaging in work activity that's above a certain threshold, then even if you are disabled for other purposes, you're not going to meet the definition of disability for Social Security because your work activity is above that threshold. But if you're not working, then you're going to get past step 1 of the analysis because you're not engaged in substantial gainful activity. So if you get past step 1, then you move to step 2. And that question is, do you have a severe impairment or combination of impairments that meets the duration requirement? Essentially, what this means is, do you have a medical diagnosis from an acceptable medical source? So a treating provider like a medical doctor or a physician's assistant or a nurse practitioner. And does that diagnosis, does that impairment cause more than minimal limitation in your work-related abilities? Does it reduce your ability to perform work activities? And if it does, and if that impairment has lasted or is expected to last for more than 12 months or result in death, then you have a severe medically determinable impairment at step 2 of this analysis. And then you go to step 3. Step 3, the question becomes, does that impairment or combination of impairments meet and or equal one of the Social Security listings? And at the next slide, we're going to go over what the listings are. Now, so I'm not going to talk in detail about it now, but what you should know is that most people don't meet the listing of impairments, but they still may be disabled for Social Security purposes. But if you do meet a listing, then the analysis ends there, and you are found disabled for Social Security purposes. And again, if you meet the non-medical eligibility criteria, then you will be awarded benefits. So it's possible to win your application or your appeal at step 3, the listing step here. But if you don't, that's fine. And again, most people don't. So then you go to the next step, step 4. However, between steps 3 and 4, an assessment is done by the decision maker in your case. So that could be the analyst at Disability Determination Services, or if you've had to go through further appeals, it would be the administrative law judge at the hearing office. They have to come up with a residual functional capacity assessment, an RFC. And we'll talk more about what an RFC is in a few moments. But once they determine what your RFC is, then they're going to then go to step 4, and they're going to ask, given that functional capacity assessment, do you have the ability to perform your past relevant work? And what that essentially means is, given that assessment, can you do any of the work that you've done in the past 5 years? And if you can still do that work, despite the fact that you have disabling impairments, then you don't meet the definition of disability for Social Security. But if you can't do that past work anymore, then you then move to step 5 in this analysis. And that step is whether considering your medical vocational factors, can you make an adjustment to other work that exists in significant numbers in the national economy? And we'll talk about that some more in a few moments as well. So again, the prior slide, we had the definition of disability. It's a very compact definition. What it means in practice, though, is do you satisfy the 5-step sequential evaluation process? Can you be found disabled at step 3, meaning do you meet or equal a listing, or can you be found disabled at step 5, where taking into account your medical vocational factors, that would be your age, your work history, your education, and your residual functional capacity assessment, that is the limitations that you have given your impairments, can you do any other work that exists in significant numbers in the national economy? So let's go back to step 3, though. Again, this is a step where you can win your case. So what are the listings? So Social Security used to publish an actual physical publication that was called the Blue Book, the Disability Evaluation under Social Security. You can now find it online at this link that I have here on this slide. So in this Blue Book, in the listings book, There are 14 body systems that are categorized. So, for instance, there's a whole set of listings for mental health impairments. There's a whole set of listing for um, muscular skeletal impairments. There's a whole set of listings for neurological impairments, and so on. And then within those body systems, there are specific criteria. And if you meet the exact criteria for your particular impairments, then there is no further assessment of your work history or your age or your education. You are just automatically found disabled, at least medically speaking, at that stage. So that's step 3. So here's an example of a listing, for instance, in that blue book. This is listing 1.15 for disorders of the skeletal spine resulting in compromise of a nerve root. And if you have the criteria listed in section A, a neuroanatomic radicular distribution of one or more of the following symptoms consistent with compromise of the affected nerve root, with pain, paresthesia, or muscle fatigue, and you have the following radicular distribution of neurological signs present during physical examination, etc., then you, in the following sections C and D, then you would meet that listing and there would be no further analysis done in your case because your medical records, the underlying objective medical evidence, laboratory findings, and clinical signs meet this exact criteria. And so you would be awarded disability, at least you would be found medically disabled. But again, most people don't meet a listing, but they can still be found disabled under Social Security's rules. So this is when then we move to step 4 of the analysis that we talked about. Between steps 3 and 4, however, the adjudicator has to offer a residual functional capacity assessment. And that's an assessment of an individual's ability to do sustained work-related physical and mental activities in a work setting on a regular and continuing basis. And that means 8 hours a day for 5 days a week or an equivalent work schedule. An RFC only considers functional limitations and restrictions that result from your medical impairments. And it is not the least that you can do despite your limitations, but it's the most that you can do given your medical impairments. So Social Security breaks up an RFC assessment into several components, an exertional limitations component and a non-exertional limitation component. So what is an exertional limitation? These are your limitations in physical strength in 7 categories. Your ability to sit, stand, walk, lift, carry, push, and pull. So Social Security is going to determine based on your medical records and opinion evidence in your file, maybe from your own doctors or from their doctors if they sent you out for one of their examinations. They're going to try to determine what is the most you can sit for, the most you can stand for, walk, lift, carry, push, and pull. In addition, they're going to try to assess your non-exertional limitations because of your impairments. So non-exertional limitations or any limitations that you have in your work-related abilities that are not strength-based. So say your ability to understand and remember things, your ability to respond to coworkers or supervisors, any limitations that you have in communication, say for instance, hearing or speaking, any environmental limitations that you have, like you can't be around fumes or noises, any manipulative limitations that you have, like your ability to reach or handle, maybe visual limitations that you may have because of your impairments, or postural limitations, say your ability to stoop and climb. So Social Security is going to assess all these domains, and they're going to try to figure out what is the most you can do in these categories given your physical and mental health diagnoses and impairments and the limitations that arise from those impairments in regard to your work-related abilities. After they do that, again, we move to step 4, and they're going to ask, given this assessment, given the fact that they've said that you're limited to light work, but you can only perform, for instance, simple routine repetitive tasks, and you can't be in a production-paced work environment. That's just a hypothetical. They're going to ask, can you do your past relevant work? And that's going to be any work that you've done within the past 5 years in general. if you perform that work long enough to learn how to do it and it was for more than 30 days. And this is your burden to prove to Social Security that given all your limitations, you can't do that past relevant work. So it's really important when you're applying for disability that you properly fill out the work history reports that will be sent to you at some point in the initial application or appeals process, where Social Security is going to ask you in detail about how your past work was actually performed. And you want to make sure you give them all the details that you can about how that work was performed. The more details, the better. So exactly how long would you have to walk or stand for or sit for in that job? How much did you have to lift? How frequently would you lift weights, etc. The more details, the better. That way they can assess whether or not you're still capable of doing that based on the limitations that they've assessed that you had. If you get past step 4 in the analysis again, then you go to step 5, which is the other step where you can win your case at. And in this step, they're going to be asking whether you can perform other work that exists in significant numbers in the regional or national economy, given your functional capacity assessment and your age, education, literacy, and work history. And Social Security uses something called the Medical Vocational Guidelines to assess whether or not there's work available for you in the national economy for specific cases. So generally, for folks that are 50 or above, the medical vocational guidelines make it easier, we'll say, to qualify for disability given your age and functional capacity assessment to have a finding of disability. But if your impairments are solely mental health based and not physical or exertional based, then generally the grids don't directly apply, but they're used as a framework to determine whether or not other work exists in the national economy. And it's Social Security's burden to prove that other work exists in the national economy. And how they generally do this, at least when you go to a hearing in the appeals process, is they'll have somebody called a vocational witness that is present at the hearing, whose job is to determine, based on your physical and mental health limitations, whether or not, based on their expertise and knowledge, other jobs do exist. This is a very, very complicated step in the analysis process, but I just want you to be aware of what happens internally when an adjudicator is deciding whether or not you meet that medical definition. So that is a very short summary about what it means to be found medically disabled under Social Security's rules. There's this very compact, concise definition of disability. But when you break it out in practice, really what Social Security is doing is following this 5-step evaluation process that we went through today. And ultimately, what you're trying to do is you're trying to prove that based on your physical and mental health impairments and the limitations that arise from those impairments that impact your work-related abilities, whether or not there are other jobs that you can do in the national economy. And Social Security has adopted a administrative shortcut, so to speak, for folks that are 50 or older. And that's called the Medical Vocational Guidelines, or the GRIDS, which helps them with an analysis about whether or not other work exists in the national economy. Of course, if you're below the age of 50, those medical vocational guidelines don't directly apply, but the same framework applies. And essentially what you're trying to prove is that based on all of those conditions that you have, that there are no jobs that you would be able to do on a sustained basis in the national economy. And by sustained basis, we mean 8 hours a day, 5 days a week, or an equivalent work schedule. So I will open the floor to questions now, if there are any. I look forward to talking to you, but I do want to remind you, as Marissa said at the top of this presentation, that please do not share confidential advice in this forum. This is a public forum. Again, this does not establish an attorney-client relationship. I can answer general questions you have about the disability process, but I can't answer questions specific to your situation, especially not in this forum. And if you're looking for assistance with your disability case, you are welcome to call Legal Aid of North Carolina's helpline at 1-866-219-5262. That's 1-866-219-LANC to see if we can assist you with your Social Security issues. So, Marissa, do we have any questions?
Not seeing any questions right now, but gonna leave it open. If you have a question, you can post it in the Q&A box on Zoom or the comment section on Facebook. Please be aware you cannot unmute in this forum. So if you have a question, you need to type it in one of those two places. So gonna leave just a few moments here to see if any questions come in. Someone's wondering how can they get a copy of the evidence that I guess the adjudicator made their decision on?
Okay, good question. So it depends on what stage you are at in your appeal. So if you've applied and you were denied, you're going to receive something called a notice of disapproved claim in the mail. And you'll have 60 days to appeal that notice of disapproved claim. In your case, at the next level of appeal goes to something called reconsideration. Essentially, it gets sent back to the Disability Determination Services again for a new assessment, an independent assessment from a different analyst about whether or not you meet the definition of disability, and new medical consultants will review your file. And if you're denied again at that stage, you're going to get something called a notice of reconsideration in the mail, and you'll have 60 days to appeal that again and to request a hearing before an administrative law judge. That will be at one of the offices of hearing operations, either in the state or around the country. And then if you're not successful there, you can appeal the case again to the highest level of appeal within Social Security called the Appeals Council. So there are various stages of appeal, and I'm telling you that because you may have to request your medical, your file from different places depending on where you're at. But if you got an initial denial from DDS, your case is still under the jurisdiction of your local Social Security field office. And so how you would get your the DDS file, the medical record file, is by requesting that directly from your field office if you're at that earlier level. If your case is at the Office of Hearing Operations, then you would call the Office of Hearing Operations, and you would know it's there because you're going to be getting letters from there, and it will have an address and a phone number to call. So you would call them directly, and you would ask them to send a copy of your file to you, and they can do that by email, secured email, in a PDF form that's password protected, or they can still burn it on a CD-ROM, and you can have it that way as well. If it's at the Appeals Council, then you're gonna have to write to the Appeals Council to get a copy of your file from them. And if your case is at the Appeals Council, you'll know that too, because you will have gotten letters from them, and there'll be a phone number there as well. So it's a long way of saying, yes, you can ask them for copies of your file, but it really depends on where you're at in terms of the appeal process about who you should be contacting.
Sure. And this next question, I think, is asking in terms of when they're looking at is there relevant work in the national economy or something like that. Does it, where someone lives, does that have any bearing on that assessment? Like if someone is living in a rural area with limited opportunities, are they then assessed on what's available? You know, they're assessed on that national. Is there an expectation that they move or
Yeah,
something?
this is a really good question, and it's actually unfortunately a little bit complicated. So yeah, Social Security can't say that the job that you can perform is, say, I'm trying to think of a job right now that would not exist in North Carolina. So just offhand, I'm thinking that, essentially most of the almonds in the country come from California. And let's say the job they identified is somebody that helps with harvesting of almonds, for instance, in California. Social Security can't say that you could do that job if you live in North Carolina. It doesn't exist in the regional economy. But in general, though, the question is whether or not the job exists in the national economy in significant numbers. And so, if they can identify some basic unskilled work that may still exist in the national economy, even though there may only be a few jobs around your area, they probably will have met their burden. But this is where you need an attorney to be helping you out at that hearing, because if they do come up with a job, that clearly does not exist anywhere in North Carolina, then that would be something that could be addressed through an appeal.
Let me see. Someone's asking at what point should they reach out to an attorney or legal aid specifically?
Okay. I, my recommendation is that if you have a pending application before the Social Security Administration, um, you're always probably better off by having assistance with that application. You have enough going on in your life, in your day-to-day life. Having an attorney or an advocate who can help you with the multiple phone calls that need to be made to SSA, collecting the medical evidence, submitting it, will take a burden off your shoulders. So I would recommend it's always beneficial to have an advocate or an attorney helping you out at any stage. Now, at Legal Aid of North Carolina, we generally are not able to help you with an initial entitlement case, a case that when you're applying for benefits, unless two private attorneys have told you that they're not able to help you. And that's also going to depend on our resources at Legal Aid in North Carolina, if we have the available resources at that time to help you, and if you meet our financial eligibility criteria. But there are many, many private disability attorneys throughout the state of North Carolina that do this work. And so one way of finding Social Security attorneys that may exist in your area is to go to the North Carolina State Bar website, and you can actually search by specialty. So the North Carolina State Bar has a specialization certification program, and several attorneys throughout North Carolina have decided to specialize their practice in Social Security disability, and they've been certified as specialists by the State Bar because they've met certain requirements. And if you search by specialty, you'll find the attorneys, for instance, that are listed as specialists. So that's a good way to find attorneys that do this work and specialize in this work, at least in North Carolina. Coming back to the general question, when should you get an attorney? My opinion is the earlier the better. You can have somebody assisting you, taking that burden off your shoulders and developing your case. That's my recommendation.
What happens when the evaluators don't have someone's complete records or medical records, and that's what they're basing their evaluation off of incomplete information?
If they don't have all the evidence that they need because they're missing it, it definitely is the obligation of the claimant or the claimant's attorney to help Social Security try to get those records so they have a complete record. In fact, it's a duty of the claimant to submit and or inform Social Security of all evidence, medical evidence that relates to the case. But if Social Security doesn't have all the evidence they need, that could be a reason why they have denied you. If they don't know that certain medical evidence exists, say for instance, an MRI of your lumbar spine, but that evidence may have been crucial, then you might get a denial because they didn't know that it existed. And so your remedy for that is to appeal it, and at the next level, make sure that you get that MRI in, for instance. Yeah, it does happen that Social Security will not on its own get all your medical records. Maybe they didn't know a source existed, or maybe the source did not respond to them, which happens often too. They request records and the medical provider doesn't respond to the request for whatever reason. So that does happen. Ultimately, though, it is the burden of the claimant to get Social Security all that evidence. Social Security puts that burden on the claimant, and again, that's why it may be beneficial for you to reach out to an advocate or attorney to help you with this, so they can also help you get those medical records.
Awesome. Well, I am not seeing any more questions, so I'm going to go ahead and say thank you all for joining us, with a special thank you to Brian for presenting and for answering all those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn programs, such as SNAP, Child Custody, Simple Divorce, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a good rest of their afternoon.